A federal judge is again telling the Trump administration it must allow members of Congress to make surprise oversight visits to ICE detention facilities. The Department of Homeland Security imposed a new policy last month requiring a week's notice before legislators can go into detention centers. A judge has found that policy is illegal. This has gone back and forth in courts for months after Democratic Congressman Joe Neguse and Jason Crow from Colorado sued the administration last year. They demanded that they still have the right to do those oversight visits, which are specifically protected under law. This is the judge's third time blocking or limiting the federal government's attempts to prevent unannounced oversight. The Trump administration is appealing.
You guys, Adam is here. So this hust happened. Trump built his entire legal defense on two pillars: presidential immunity and being too busy to stand trial. Both just collapsed simultaneously. Federal judges have spoken in unison. The delays are over, the immunity is gone, the trials are happening. And if the juries convict, prison is no longer theoretical.
Joe, that Supreme Court ruling recognizing former President Donald Trump's immunity claim for official acts as president, though rejected it for unofficial acts. The majority opinion delivered by Chief Justice John Roberts states while the president is not above the law, that he may not be prosecuted for exercising his core constitutional powers, and he is entitled to at least presumptive prosecution for his official acts. Still, it states that Trump is asserting a far broader immunity than the limited one we have recognized. Now, in the dissent, Justice Sonia Sotomayor countering that it makes a mockery of the principle foundational to our Constitution and system of government that no man is above the law. Joel, this 6-3 decision will impact whether or not Trump ultimately faces a federal role for his role in the January 6th insurrection. Trump issuing a short statement following that decision on Truth Social, posting, "Big win for our Constitution and democracy. Proud to be an American."
Let me walk you through exactly what happened, because this is one of those moments where the legal system finally caught up with someone who thought he could outrun it forever. For the better part of 3 years, Trump's legal strategy has been defined by two words: delay and immunity. Delay every case through endless procedural motions, appeals, and legal brinkmanship. Claim immunity from prosecution for anything he did while in the White House. The goal was simple: push everything past the election, get back into power, and then use the levers of government to make all of it go away.
This morning, the president tweeted his intentions, writing, "We were put in this position of power and importance to make decisions for the people who so proudly elected us, the most important of which has long been considered to be the selection of United States Supreme Court justices. We have this obligation without delay." Our Paula Reed has obtained a list of President Trump's top 3 contenders, according to a source familiar with the White House vetting process. They are federal circuit court judges Amy Coney Barrett, Barbara Lagoa, and Amul Thupar. And Friday night, Senate Majority Leader Mitch McConnell promised to hold a vote on President Trump's nominee.
It was a cynical strategy, but it was also effective. It worked. It bought him time. It kept trials from happening. It allowed him to campaign without the weight of criminal convictions hanging over his head. And then he won. But something unexpected happened after Trump returned to the White House. The judges who had been patiently working through his legal challenges stopped being patient. The courts that had allowed his appeals to run their course suddenly decided that enough was enough. And in a series of rulings that have fundamentally altered the trajectory of Trump's legal fate, federal judges dismantled his entire defensive architecture piece by piece. The first blow came from a federal appeals panel. For months, Trump had been arguing that he possesses absolute criminal immunity for any actions he took while serving as president. His lawyers made the case that without this protection, future presidents would be afraid to make tough decisions, that the threat of prosecution would cripple the executive branch, that the Constitution itself demanded that former presidents be shielded from criminal liability for their official acts. It was an audacious argument, one that would have placed former presidents in a category above the law that applies to every other American citizen. The appeals court was not impressed. In a unanimous ruling, all 3 judges, including those appointed by Republican presidents, rejected Trump's immunity claim outright. Their reasoning was devastatingly simple. Whatever protections a sitting president may have while in office, those protections end the moment he leaves the White House. Once you become a private citizen again, you are subject to the same laws as everyone else. The court went further. They said that accepting Trump's theory would fundamentally break the Constitution by creating a class of people, former presidents, who are above the law, and that, the judges wrote, is something the Constitution does not permit. No one is above the law. Not the president, not the former president, not Donald Trump. That ruling did more than just reject Trump's legal argument. It cleared the path for his election interference case to move forward immediately. Prosecutors no longer have to wait for the Supreme Court to weigh in. They no longer have to spend months litigating whether Trump can be charged. The appeals court has decided he can be charged, and the case is now hurtling toward trial with nothing standing in its way. But the courts were not finished with Trump. While his lawyers were fighting the immunity battle, they were also waging a separate campaign to delay his trials based on his schedule. The argument was simple. Trump is the President of the United States. He has responsibilities. He has a country to run. He cannot be expected to sit in a courtroom for weeks while prosecutors present evidence against him. It would interfere with his duties. It would create a constitutional crisis. It would be unfair to the American people who elected him to lead. A federal judge looked at this argument, looked at Trump's actual behavior, and said absolutely not. The ruling was clear and unambiguous. Being president provides no special accommodation when it comes to trial scheduling. If you are charged with crimes, you stand trial. Your job does not matter. Your political ambitions do not matter. You show up like every other defendant and you face the justice system like every other American. But here is where the ruling got truly devastating for Trump. The judge pointed out that while Trump's lawyers were in court arguing that he was too busy to defend himself, Trump himself was busy filing new lawsuits. He was suing media companies. He was suing political enemies. He was actively using the court system as a plaintiff, initiating legal proceedings, demanding his day in court. So which is it? Is he too busy for legal proceedings, or is he only too busy when he is the one being accused? The hypocrisy was laid bare, and the judge was having none of it. You cannot have it both ways, the ruling effectively said. If you have time to be a plaintiff, you have time to be a defendant. The trials will proceed, and you will be there. With that ruling, Trump's second major shield was shattered. He could no longer hide behind immunity. He could no longer hide behind his schedule. The path to trial was now clear, and there was nothing left to stand in the way. Now, let's talk about what happens when Trump actually gets to trial, because this is where the stakes become truly existential for him. For years, the conversation around Trump's legal exposure has been abstract. Would he ever actually face a jury? Would the courts allow a former president to be tried? Would his status as a candidate and then as president protect him from accountability? Those questions have now been answered. Yes, he will face a jury. Yes, the courts will allow it. And no, his status does not protect him. What we are looking at now is a scenario where multiple criminal cases against Trump are moving toward trial simultaneously. The election interference case in Washington, the classified documents case in Florida, and looming over all of it, the felony conviction he already has from New York, the hush money case where a jury of his peers looked at the evidence and found him guilty of 34 counts of falsifying business records. That existing conviction matters more than most people realize. When a federal judge sentences Trump after a conviction in one of the federal cases, they are required to consider his criminal history. And Trump's criminal history now includes a felony conviction. He is not a first-time offender. He is a repeat offender, and federal sentencing guidelines take that very seriously. Let me walk you through how federal sentencing works. It is not a free-for-all where judges can do whatever they want. There are guidelines, strict guidelines, that judges must follow. Those guidelines take into account the severity of the crime, the defendant's role in the offense, and most importantly for Trump, the defendant's criminal history. The more serious the crime and the more extensive the criminal history, the higher the recommended sentence. Trump is charged with conspiracy, obstruction, election interference. These are not minor offenses. They are felonies that carry serious penalties under the guidelines, and when you add his existing felony conviction to the calculation, the guidelines point in one direction: significant prison time, not probation, not house arrest, years in federal prison, possibly a decade or more, depending on how the charges are structured and whether the judge runs the sentences consecutively. Now, could a judge give Trump a lighter sentence? Technically, yes. Judges have some discretion to depart from the guidelines, but they have to justify that departure. And what would the justification be? That he is old? Many defendants are old and still go to prison. That he is politically important? That is actually an argument for a harsher sentence, not a lighter one, because it shows he abused a position of trust. That he is the president? That is the opposite of a mitigating factor. It suggests he should be held to a higher standard, not a lower one. The reality is that there are no legitimate legal grounds for giving Trump special treatment at sentencing, and everything we know about Trump's behavior throughout his legal battles suggests that judges will have little sympathy for him when the time comes. Consider how Trump has conducted himself. He has attacked prosecutors by name. He has attacked judges, including the family members of judges. He has attacked witnesses, trying to intimidate them before they can testify. He has violated gag orders repeatedly, daring judges to punish him. He has shown zero remorse for any of his actions. He has treated the entire legal system with contempt, as if it were something to be mocked rather than respected. All of that matters at sentencing. Judges are human beings. They watch what defendants do. They see whether a defendant takes responsibility for their actions, whether they show remorse, whether they respect the legal process. Defendants who do those things often receive more lenient sentences. Defendants who do the opposite, who are defiant, combative, contemptuous, they receive harsher sentences. Trump has done the opposite at every turn, and judges have long memories. Then there is the civil fraud judgment from New York. A judge in that case looked at the evidence and found that Trump and his company committed repeated, deliberate fraud over many years. The judgment was for $354.9 million plus interest. The judge also imposed multi-year bans on Trump running businesses in New York. That civil finding is now part of the public record. It is a judicial determination that Trump is a fraudster who engaged in a pattern of dishonest conduct. When a criminal judge is deciding how to sentence Trump, they are going to see that civil finding. They are going to see a documented history of illegal behavior that goes beyond the criminal charges they are sentencing him for, and that history will make them much less inclined to show leniency. It shows that Trump is not someone who made a one-time mistake. It shows that he is someone who has spent years operating outside the law. So where does this leave Trump? Let's put it all together. The immunity defense that was supposed to protect him from prosecution is dead. A federal appeals court killed it, ruling that former presidents do not have blanket criminal immunity and that Trump's theory would break the Constitution. The scheduling excuse that was supposed to delay his trials is dead. A federal judge killed it, ruling that being president provides no special accommodation and pointing out the hypocrisy of Trump filing lawsuits while claiming he is too busy to defend himself. The path to trial is now clear. Trump will face juries. He will have to sit in courtrooms while prosecutors present evidence against him. He will have to listen to witnesses describe what he did. He will have to let 12 ordinary citizens decide whether he is guilty. And if those juries convict him, which given the strength of the evidence against him is a very real possibility, then the sentencing phase begins. And at sentencing, the picture is bleak for Trump. He is a repeat offender with an existing felony conviction. He faces serious charges that carry significant prison time under federal guidelines. He has shown no remorse and has treated the legal system with contempt. He has a civil fraud judgment against him documenting a pattern of dishonest conduct, and there are no legitimate legal grounds for giving him special treatment. Prison is not a hypothetical anymore. It is not something to joke about or dismiss. It is a real, tangible outcome that Trump and his legal team have to prepare for, and there is nothing left that Trump can do to stop it. He cannot delay anymore. The courts have cut off his delay tactics. He cannot claim immunity anymore. The courts have rejected that argument. He cannot claim he is too busy. The courts have laughed at that excuse. All that is left is trial, and after trial, if the verdict is guilty, then prison. Think about what that means. A former president of the United States, a man who once occupied the most powerful office in the world, sitting in a federal prison cell. It is almost impossible to imagine. And yet, it is now more likely than it has ever been. The legal system that Trump spent years trying to bend to his will has finally straightened itself out. The courts that he attacked, the judges he insulted, the prosecutors he tried to intimidate, they have all done their jobs. And their work has led to this moment where Donald Trump stands stripped of every defense, every excuse, every shield, and faces the very real prospect of spending the rest of his life behind bars. The political implications are staggering. Trump is supposed to be running the country. Instead, he is fighting for his freedom. He is spending hours with his lawyers instead of with his advisors. He is preparing for trial instead of preparing policy. He is watching judges hand down rulings that seal his fate instead of signing legislation that shapes the nation. His presidency, already chaotic and dysfunctional, is now being consumed entirely by his legal peril. His supporters will rally around him. They will scream about persecution and witch hunts, but the broader public will watch the trials unfold. They will see the evidence. They will hear the witnesses. They will watch as juries deliberate. And they will have to decide whether they want a president who is also a convicted felon, a president who may be going to prison, a president who is spending his time in courtrooms instead of the Oval Office. Republicans in Congress will face their own reckoning. They have spent years defending Trump, making excuses for him, enabling his worst impulses. But when he is sitting in a courtroom as a criminal defendant, when the evidence is played on every screen in America, when juries start returning guilty verdicts, will they still defend him? Will they still stand by a man who may soon be wearing an orange jumpsuit? Or will they finally break with him and try to salvage what is left of their party? These are the questions that will define the next phase of American politics, and they are all happening because federal judges, in a series of rulings over the past days, finally said, enough. Enough of the delays. Enough of the immunity claims. Enough of the excuses. You will stand trial. You will face juries. And if you are convicted, you will face the consequences. Trump is frozen. There is nothing left for him to do. He has exhausted every legal maneuver. He has used every delaying tactic. He has made every argument. And none of it worked. The courts have spoken. The trials are coming. And for the first time in his life, Donald Trump is facing a reality he cannot talk his way out of, cannot bully his way out of, cannot delay his way out of. He is going to trial, and if the juries say guilty, he is going to prison. That is the new reality. That is where we are, and there is nothing he can do to stop it.